Yes.
All right. And Miss Beelan, can you unmute? Are you Brittany Beelan?
Yes, I am.
Okay. All right. We're on the record now in Beelan versus Beelan, case number 2419895. We have Mr. Blumberg here by Zoom on behalf of Mr. Beelan, who's with him. And we have Miss Beelan also here by Zoom. This is set for hearing today. Mr. Blumberg, you filed a motion. Your client is asking for...
The hearing begins with both parties appearing via Zoom as the court goes on record. The judge formally introduces a case and acknowledges the presence of each party and their representatives. The matter before the court involved a motion filed by the respondent, seeking relief from a previously issued ex parte order that required him to pay certain household expenses. The judge invites counsel to present arguments in support of the motion, setting the stage for a careful review of the circumstances.
Relief from ex parte order that was signed by the court, requiring him to pay certain household expenses and so forth at the beginning of the case. Anything you wanted to state by way of oral argument in support of your motion today?
Well, I would just again reiterate to the court what my motion and supporting brief suggests, that the court signed an order based on information that was not accurate. I don't know if there were intentional misrepresentations made, but the net effect of those is that you signed an ex parte order requiring my client to pay certain obligations, when the reality is that when the motion that was filed, it was asserted that she was not working and that she failed to indicate to the court that she had her boyfriend living there, a roommate, who was contributing financially to the obligations. Those are certainly material facts that were either omitted carelessly or intentionally. The bottom line is that I think that had the facts been properly represented to you, you would not have signed such an order. So we're asking the court at this point to rescind that order. My client has been contributing financially, and he's prepared to continue to do so. But certainly, based on the facts that you were presented, I think that ex parte order was inappropriate.
Mr. Blumberg, are there any temporary orders regarding child support in place? Just looking through the file, you might know off the top.
No, there is not.
Okay. And how much is your client contributing monthly at this point?
Okay, he's paying between $150 and $200 a month.
Okay. All right, Ms. Beeland, what's your side of this?
The reason why we decided for Chauncey to pay $600 worth of mortgage, because it is on his name too, along with mine. And during that time that I'm having a hard time understanding this. The reason why we put this, because
Counsel for the respondent argues that the original order was based on incomplete and inaccurate information. It is explained that the court was not fully informed about key financial details, including the opposing party's employment status and the presence of additional financial support within the household. These omissions are presented as material factors that could have significantly impacted the court's initial decision. Based on this, the respondent requests that the order be reconsidered and modified to reflect the true financial situation.
Was working at a restaurant, barely making minimum wage, trying to have fully intent of getting my job that is now, I work full-time at Kohl's, just so he could just help pay the mortgage. That's all I was asking. And my boyfriend, he is no longer in the home, but during that time, he was helping pay all the smaller bills, helping me out with that type of stuff. And up until he recently left, he was helping me pay all my small bills, and I was paying my mortgage and trying to keep on boat on that. And I have caught up completely on my mortgage so far. It's been hard, but I've been dealing. So I was just asking for help with that. That's all.
All right. Anything in response to that, Mr. Blumberg?
Judge, I don't know that we need to go into the facts why the boyfriend is no longer there. My understanding is he's been arrested and he probably has a no contact provision. But I don't guess that that's really relevant at this point. My client is willing to continue to pay some money to assist, and certainly the kids are with him half the time. So I just, I'm always reluctant when I see these ex parte orders, when facts are presented to the court, and you have no way of knowing whether they're accurate or truthful or not. And I understand it's always best to err on the side of caution, but I genuinely believe that had the facts been properly presented, I don't think he would have signed this order. He'll continue to pay those expenses that he's been paying.
Okay. And Mr. Blumberg, your client is on the mortgage as well, his name?
Yeah. Yes, it is.
All right. So presumably he's got just as much.
In response, the opposing party explains that her request for financial support was made during a time of financial hardship. She states that she was working a low-income job and struggling to meet her financial obligations, including mortgage payments. While acknowledging that she had some temporary assistance with minor expenses, she emphasizes that the primary financial burden remained hers. She also notes that her situation has since improved, but her initial request was made in good faith to maintain stability.
An interest in keeping that mortgage current, as Mrs. Phelan does?
Yeah, he does. But he has the expense of another place. Again, when these parties separated, my understanding was that they had an understanding as to how the expenses were going to be shared. That wasn't reflected in any written document, unfortunately. But yes, you're right. He has a monetary interest in that property.
Right. Give me just 1 second. I just want to. All right. Is there an amount that we can put on the record here today that your client is willing to contribute per month?
$200. Yeah, my client said he can pay $200 a month.
All right. Okay. So I think that's fair during the pendency here, given the circumstances. So Mr. Blumberg, the court is going to modify that order and have it reflect that your client is going to pay $200 per month towards the household expenses. So if you can draft an order that will reflect that and submit that to the court, and we'll go forward from there. Ms. Phelan, do you have any questions about that?
No, I appreciate any of the help I can get. So I just appreciate it. Thank you.
Okay. Mr. Blumberg, anything further on this file today?
No, Judge, thank you.
Okay, thank you. All parties are free to disconnect at this time. Okay, looks like we have both parties connected, so we'll go on the record. This is Van Til versus Van Til, file number 1717089. The record should reflect that both parties are connected by Zoom. This is set for a motion today. Mr. Van Til, you filed a motion to cease spousal support, and your motion's based on the fact that Ms. Van Til remarried at the end of 2024. Is that correct?
Yes.
Okay. Ms. Van Til, is that correct?
Yes.
Okay. Are you contesting the discontinuation of the spousal support?
After hearing both sides, the judge carefully evaluates the financial positions and responsibilities of each party. The court notes that both individuals have a shared interest in maintaining the property associated with the mortgage. Taking all factors into consideration, the judge determines that a modification of the existing order is appropriate. The court sets a reduced monthly contribution amount, reflecting a more balanced and fair arrangement, and instructs counsel to prepare and submit a revised order.
To an extent, I feel that I was pretty generous back in 2021 when I let him off on over $12,000 in arrearages at the time. I'm willing to drop down to $500 a month for, let's say, another 3 years.
Okay, Mr. Van Til, what's your position on that?
No, I disagree.
Okay.
I
All
disagree.
right, well, you know, here's the thing. I reviewed the original judgment of divorce, and it does allow for the court to modify spousal support based on a change in circumstances. Ms. Van Til, and frankly, I'm surprised it doesn't contain the language that if you remarry, typically once a party remarries, I mean, that's a change in circumstances that warrants the cessation of payment of spousal support. And the whole idea of spousal support is that you don't have the assistance of your marital partner anymore to support you. And when you get remarried, that's no longer the case. So it really, to me, the only fact here that would be a potential issue is whether or not you were actually married, or remarried, I should say. And it sounds like that's not a fact that's in dispute. So for that reason, the court finds that the spousal support should cease. And so, Mr. Van Til, you need to file something with the court that indicates that the court is granting your motion. You can use a form like you used to file your motion in this case, okay?
Okay.
But that's an important step for you to follow up on, because until I sign that order, I mean, that's what actually stops your obligation for spousal support. So it's important that you submit that as soon as possible to the clerk's office here in Gaylord.
Okay, so it's the form just like the one I sent for this hearing.
Yeah, well, you can find the form in the same place. It's going to be just a blank order. And you're going to fill in there that the court is granting your motion and spousal support will stop as of February 3rd, okay?
Okay.
Ms. Van Til, did you have any questions about that?
No.
Okay. All right. Thank you. That's all for this hearing today. Both parties are free to disconnect at this time.
Thank you.
In a separate matter, the court addresses a motion to terminate spousal support based on remarriage. The judge explains that spousal support is intended to provide financial assistance after divorce, but it is not meant to continue indefinitely without justification. A significant change in circumstances, such as remarriage, can warrant termination of that support. That I end this case. The remarriage of the receiving party is confirmed and not disputed. The court recognizes this as a decisive change that alters the financial relationship between the parties. Accordingly, the judge grants the motion and orders that spousal support be terminated. The court further instructs that a formal written order be submitted to finalize the decision, noting that the obligation remains in effect only until the order is officially entered. With no further matters to address, the proceedings conclude and the court stands adjourned.